Hi friends, I'm Chelsea Grayson coming to you once again from the Office of the CEO. This is my show where I can help you be more successful in your current career, and I can also help you successfully transition to a new career. So today is a continuation of my multi-part series on understanding legal agreements, so that even to the extent you're not a lawyer, even to the extent you've retained a lawyer, you can independently review your deal documents so you can make sure that the transaction you thought you were entering into is actually the one that's memorialized in your deal documents. Because as I've been saying for the past few episodes, whatever is in those deal documents, whether it's one contract or multiple contracts, is what is going to govern your deal, rather than the back of the napkin or the conversation that you and your counterparty had in the bar when you guys were cooking up whatever deal you were going to enter into. So today I want to briefly continue discussing the so-called general section, the miscellaneous section. This is the section that comes towards the end of each legal agreement that contains what a lot of people call boilerplate, right? These are the sections that a lot of people overlook, and they can really get caught in certain traps later on after they've already inked the deal because they didn't review these sections carefully enough. So today I wanted to go over one important provision that generally shows up in the so-called miscellaneous or general section. And that's typically called the governing law section. This is a section that talks about, quite frankly, what is the governing law to the extent that the parties to this transaction have a dispute, they have some sort of an argument, there is some sort of controversy that arises under this agreement. What is the law that is going to apply in terms of interpreting and working out this dispute? This is incredibly important. So first of all, when you're trying to figure out which law, and this is generally the state law that will apply, right? Because if it's a federal issue, the federal laws will take over and there's really no choice there. But we're talking about state contract, state business disputes between the parties. For example, a breach of contract, some sort of tortious interference with commercial transactions, maybe a wrongful termination case if it's an employment agreement, for example. And in that case, state law will take over. So typically, in order for a choice of law provision to be enforced, for a judge to hold up, in other words, what the parties agreed to here, the law chosen has to have some sort of a nexus to the underlying deal or the parties themselves. What do I mean by nexus? I mean, there has to be some sort of a logical connection or relationship between the law that the parties have chosen to govern disputes under the agreement and the parties or the deal. So, for example, if both of the parties are sitting in California and they choose the law of Minnesota, at first glance, that looks like there's zero connection to what's going on throughout the course of this deal, unless you maybe then take another stab at the apple and you say, oh, okay, well, a lot of the business that was being transacted between these parties was taking place in Minnesota, right? So that's an attenuated connection, but at least it's some sort of a nexus. So you want to make sure that either the business is taking place where the state law is governing, or one or both of the parties is sitting in the state that they've chosen to have the laws of that state apply. So you also want to take a look at not just, is there a nexus, but is it a logical state law to apply in this situation? So for example, there are some states that have incredibly well-developed bodies of law in connection with a particular thing. So New York is well known to have a developed body of state law that governs contract disputes and business arrangements. Delaware, for example, that state law is often applied when it comes to the governing a relationship between public companies, for example, because lots and lots of public companies are actually organized in the state of Delaware. Delaware is also a great place to look for bankruptcy, various bankruptcy laws that can apply, because they get a lot of bankruptcies that come through. California is very well known for certain contract disputes and also specifically business disputes amongst parties to tech transactions. So you just sort of want to talk to your lawyer and say, is there a well-developed body of law in this jurisdiction so that there is enough case law to look at for precedent? And also, are the judges familiar with the type of dispute and contract interpretation that's going to be happening if there's a dispute under this agreement? Your lawyer will be able to answer that question, so you won't, but at least I want you to know to ask that question. And you also want to take a look at, is that body of law biased one way or the other? This is the first place bias can come up in this sort of a provision. So, for example, it is well known that California has a very well-established body of laws when it comes to employer-employee relationships, employment relationships, and to a certain extent, labor relations, and that it's a pretty pro-employee set of laws. We're skewed very much in favor of landing on the side of the employee. So you want to make sure, if you're the employer in this particular situation, that there is going to be enough neutrality in the law so that you actually want the laws of the state of California to apply, rather than thinking about a different set of state laws. Now, you might not have a choice, because to the extent that, for example, in that scenario, the employee is actually employed in the state of California and is working physically in the state of California, or virtually working in the state of California, there might not be a choice later on, and California law is going to apply no matter what. But it always helps to understand what the implicit biases in the legal authorities are before you agree to a particular choice of law. So another set of words that's typically found in governing law provisions is that the parties are agreeing to jurisdiction in a particular place. So this is so that the parties don't later on have to fight about, okay, we agreed California law would apply, but I'm sitting here in Minnesota, you're sitting there in California, I'd rather not travel, so let's battle this out in Minnesota and have a bunch of judges in Minnesota applying California law. That's a very bizarre outcome, right? But it's happened. So in order to avoid that sort of mess, you want the parties to agree, if they can, right here in the agreement, okay, we're going to have California law apply, and we will also agree that jurisdiction will take place in the state and or federal courts in California. So we all know if there's going to be a dispute under this agreement, it's going to happen in California with California law being applied, or it will happen in California with Delaware law being applied for these sorts of disputes, California law being applied for these sorts of disputes. But at the very least, all the parties know where they're headed, to the extent that there is some sort of a dispute that has to be worked out between the parties. And you want to think long and hard about this, right? Because if you agree to California jurisdiction, but you're sitting in New York, just know that if something goes wrong between you and the other party to the deal, you're going to be flying out a whole bunch to New York. Maybe these days post-COVID, a lot is being done virtually when it comes to various forms of dispute resolution, but that won't stick around forever. And there are still reasons why you might be compelled to actually physically come to California, a whole bunch of reasons. So you want to think about what the expense will be that will be involved with that. Flight, hotel, transportation once you're on the ground here, meals and all of that. And you want to think about what burden does that add to witnesses that you might want to call on your behalf, to the extent that there are witnesses. So are you going to have to pay for them to fly out and to stay and to eat? And is that going to be a hassle for them versus being able just to go downtown and testify in a courthouse somewhere downtown in Manhattan? So you want to think about all of that beforehand and think long and hard about where you agree to jurisdiction. Another issue that comes up in choice of law provisions that sometimes gets buried is, how are we going to resolve this dispute when it arises? Are we going to go straight to litigation? So we agree that we're going straight to litigation. In that case, are we waiving our right to a jury trial? A lot of times you see that in the body of agreements where they say we go straight to court. We can attempt to settle, of course, but we go straight to court. And once we hit court, we're all agreeing it's going to be a bench trial, or a trial that's just governed by the judge versus a jury trial. You do see those a lot, particularly in commercial transactions. It's not unusual, but if that's not your thing, then you absolutely need to not waive your right to a jury trial. Sometimes agreements will include language that says, look, we might ultimately end up in litigation, but we all agree that in good faith, we will attempt to mediate the dispute. So we will go to a neutral mediator, Or first we will attempt to arbitrate the dispute. And we are going to agree to have 3 arbitrators. We each get to pick one, and the third we agree on mutually. Then we can go to litigation if things fall apart. Or that's going to be binding arbitration, and we'll never get to court. So whatever the arbitrators decide is going to be binding upon the parties, no appeal, and we will decide our own rules of evidence because it's not actually in a court of law. You absolutely want to pay attention to this as well. I hope for very obvious reasons to all of you guys out there. If you thought you were going to have your so-called day in court, you'll be sorely surprised to find that you agreed to a mandatory and binding arbitration provision if you didn't read that provision carefully. And your lawyer might not think to even talk to you about it because your lawyer might have his or her own likes and dislikes. They might ultimately want to end up in arbitration because they think litigation is going to be too costly. So they might make that decision for you thinking that you won't care. You should know to ask these questions. Now, the very last thing I want to get to before we close out this episode is that some of these provisions will talk about who pays in the event that you have a dispute, it's resolved one way or the other, there's all these legal fees. Who pays for the legal fees? Winner prevail, loser pays is oftentimes drafted right into these documents. So to the extent that you lose in a litigation, whether you brought the litigation or not in a dispute between you and your counterparty to the agreement, you might be required to pay not just your own legal fees, but also the so-called victor or winner in the dispute's legal fees. Now, you might want that sort of provision if you think that no matter what, I'm always going to be the victor in a dispute between the two of us, and I have way less money than the other party, so I won't want to have to pay my own legal fees. But you, for obvious reasons, should think long and hard about whether or not, in the off chance that you do lose in this dispute resolution, are you going to want to pay the exorbitant legal fees on the other side that you probably aren't going to be able to control. So there you have it. Hope that was helpful. Please be sure and subscribe to my YouTube channel so you don't miss future episodes. And I will see you next time from the Office of the CEO.